Hello, my name is Victor Corso. I'm a career diplomat and professor of international law, and today I will be explaining the status of international law in Mexico. One of the oldest discussions in legal grammar focuses on the dynamic between national and international law. Within these discussions, two elements are of most concern. First, which system has a higher hierarchy, and second, whether both systems are part of a larger one or both coexist separately. Traditionally, two models are born from these concerns, monism and dualism. According to the United Nations International Law Commission, the United Nations specialized body in charge of promoting international law progressive development and its codification, dualism regards national and international law as two different or related systems of equal value, and monism regards domestic and international law as an integrated whole. In other words, the terms dualism and monism refers to the extent of interaction and integration between international and municipal law. On the one hand, dualism refers to the independence of both systems. This means that for international law to be applicable, action is needed at national level to incorporate international law into the internal legal system. On the other hand, monism evokes international law supremacy, promoting the view that both systems form part of a more extensive system where both interact with each other without limitations. In short, monism upholds that international law applies directly to the national legal system. In theory, national systems worldwide adopt one approach or the other, but in practice, several constitutions have both monist and dualism elements in their provisions. For these reasons, most national systems uphold a hybrid approach that will vary depending on the source of international law that wants to be applied. In Mexico's case, as most of you know, it's a civil law country, a member of the Romano-Germanic family, and as such, it has a codified system of law that derives from its written constitution. In other words, only those institutions and laws enacted or created under the Constitution will have validity under Mexico's legal system. In this regard, several constitutional provisions in Mexico refer to different sources of international law. Article 1 refers to human rights treaties. Article 21, paragraph 8 references to International Criminal Court and by consequence to its orders and judicial decisions. Article 27, paragraph 4 and 5, and Article 42, sections 5 and 6, referring to Mexico's territory, make general reference to international law, and Article 133 talks about treaties in general. Each one of these articles adopts a different approach regarding international law. Article 1, which refers to human rights treaties and guarantees, follows soft dualism. This means that once adopted by Mexico, all human rights treaties are incorporated into the constitutional block, and by consequence, the treaty provisions become an integral part of the Constitution itself. Article 21, paragraph 8, which references to International Criminal Court decisions, uphold a radical dualism perspective. Notwithstanding Mexico is a party to the Rome Statute, it also requires the Senate's approval for the President of Mexico to accept the International Criminal Court jurisdiction on a case-by-case basis. It is not hard to see how this constitutional provision is wrong from several perspectives. To mention just two examples, first, it goes against the principle of international law that states that national authorities may not rely on internal law provisions as justification for failure to comply with international obligations. Both the Vienna Convention of the Law of the Treaties and the United Nations General Assembly Resolutions 5683 on responsibility for states for internationally wrongful acts contains this principle. And second, it can be considered as equivalent as a reservation which violates Article 120 of the Rome Statute that states no reservations may be made to the Rome Statute. Returning to the analysis of how Mexico recognizes international law, it is essential to mention that Mexico's interaction with the International Criminal Court's orders has been limited simply to fulfilling cooperation requests, mainly petitions requesting the identification and freezing of assets belonging to accused persons before the court. Considering that most of the prosecutors' investigations have focused on African nations, there has been no challenge to their validity within Mexican legal system, mainly because no accused person has been found in Mexico. Nevertheless, this situation may change in the close future because of Bolivia's provisional government self-referred its situation to the International Criminal Court. In his communication to the court, Bolivia characterized Bolivia's former president Evo Morales' actions in Mexico while having political asylum as the starting point to the international crimes committed in Bolivia. In short, while there have been various communications from civil society in the past years asking the International Criminal Court prosecutor to investigate Mexico's situation, this will probably be the first alleged crime committed in Mexico to be ever investigated by the International Criminal Court. Going back to our constitutional analysis, it is essential to highlight that Mexico Constitutional Article 27, paragraphs 4 and 5, and Article 42, sections 5 and 6, follow a monism approach to benefit from future international practice. Under this approach, Mexico's airspace and maritime extensions can benefit from international law's development. In other words, these articles were drafted taking special consideration to the progressiveness of international law. Articles 27 and Article 42 codify a flexible approach that allows Mexico to expand its airspace and exclusive economic zones as recognized by international law at that moment in time. This strategy avoids having to amend Mexico's constitution every time international law is modified to expand each state's territory or exclusive zones. Finally, Article 133, which systematizes the hierarchy of norms within Mexico's legal system, follows classical dualism. This approach means that only those treaties celebrated by the President of Mexico with the Senate's approval, which are in synchrony with Mexico's constitution, will be recognized as the nation's supreme law and incorporated into Mexico's national legal systems. Once the treaty in question fulfills this formality, it will have a self-executing status under Mexican law. It is essential to mention that Mexico's constitution does not reference customary international law or the general principles of law recognized by civilized nations. Nevertheless, when it solved a controversy regarding the implementation of summertime in 2001, Mexico's Supreme Court invoked the direct application of customary international law, and by consequence, it created a precedent that serves as a basis of Mexico's recognition of the direct application of customary international law within its legal system. And regarding the principle recognized by civilized nations as mentioned under Article 38 of the International Court of Justice Statute, we can mention that those principles are already incorporated into Mexico's legal system, since Mexico is a member of the Romano-Germanic tradition and an active member of the international community. In other words, these general principles of law have been incorporated into Mexico's legal system by international law's harmonization process or by genealogy, by being a core part of its Romanic-Germanic DNA. Under Mexican law, the validity of international court decisions can be argued under two different sources. First, the compromissory clause found in the treaty that refers the dispute to a specific dispute settlement body, or second, in secondary legislation such as the Ley sobre Celebración de Tratados that has a special provision recognizing as self-executing all judicial decisions where the Mexican state participated as a party to the dispute. Besides the dozens of international trade or foreign investment disputes where Mexico has been involved over the years, 4 cases stand out because of their transcendence. The first case that I will mention is the Clipperton Island dispute, or as it's known in Spanish, Isla de la Pasión, between Mexico and France. In this case, where France and Mexico competed for its sovereignty, Mexico ended losing in 1931, 22 years after the arbitration started, the arbitration procedures, and its sovereign rights under this uninhabited coral atoll located in the eastern Pacific Ocean of Mexico coast. Second, the dispute over El Chamizal between Mexico and the United States. This dispute surrounded the interpretation of the Treaty of Guadalupe Hidalgo of 1848 and the Treaty of 1884. Specifically, Mexico and the United States have opposing views on the affirmation that the international boundary should be down the middle of the Rio Grande along the deepest channel, regardless of any alterations in the banks or channels. Mexico ended winning in 1911 the arbitration and regaining possession 42 years later in 1953 of 600 acres, which were moved to the U.S. side of the border in 1873 due to a sudden change in the Rio Grande's arm. Third, the Vena case before the International Court of Justice. In this case, the court in 2004 gave Mexico the reason and found that the United States authorities violated the Vienna Convention on Consular Relations by not providing consular notification in the cases of 51 Mexican nationals sentenced to death. In short, this omission by U.S. authorities represented a violation of Mexican citizens' rights since it prevented the Mexican government from providing consular assistance during their criminal trials. And fourth, the case of Radilla Pacheco before the Inter-American Court of Human Rights in 2009. In this case, Mexico was found responsible for the forced disappearance of Mr. Rosendo Radilla Pacheco since August 1974. This case ignited a radical change within Mexican legal system. For example, it generated several amendments to Mexico's constitutions. It incorporated the predominant principle in Mexican authorities in legal interpretation and incorporated human rights treaties to the constitutional bloc and the diffuse conventionality control that allows all federal courts to ensure compliance to human rights international treaties. Other sources of international law, such as the state's unilateral acts, have been historically recognized in Mexico as an exercise of the executive branch exclusive power over foreign policy, as recognized under Article 89, Section 10 of Mexico's Constitution. Two examples of unilateral acts celebrated recently by the Mexican government are the Merida Initiative in 2008 and the 2019 Joint Declaration between Mexico and the United States. While these documents were adopted by Mexico and the United States in a formally political context, it is crucial to recognize that nothing in international law precludes an act of this nature from producing legal effects at international level. It is required to mention that their status as joint declarations does not interfere with the creation of the unilateral obligations binding upon both governments. Currently, Mexico's Supreme Court is analyzing whether Mexico's implementation of the Migrant Protection Protocols, also known as the MPP, which are part of the compromises achieved under the 2019 Joint Declaration between Mexico and the United States, can be considered as an exercise of the executive branch exclusive power over foreign policy or not. Before concluding, it is necessary to point out that Mexico's Supreme Court has two criteria regarding the international treaties hierarchy within Mexico's domestic system. Both standards place treaties under Mexico's constitution, but they differ one from the other on the one hand by placing federal law at the same hierarchy as treaty, on the other, the most recent criteria set international treaties over federal law. In conclusion, we can affirm that most national constitutions adopt a mixed treatment of international law, since most of their dispositions focus only on treaties instead of other sources of international law. Mexico's legal systems follow this trend. The current state of Mexico's constitution, especially the hybrid treatment given to international law, is the product of a self-contained constitutional reforms since 1917. In other words, these amendments respond to the problem that emerged in a specific period of time, For that reason, there is not a cohesive approach to international law within Mexico's constitutional text. To give you an example, on the one hand, we have the text of Article 133 referring to the incorporation of treaties, that is, a copy of Mexico's 1857 Constitution. On the other, we can see a more modern approach codified in Article 1 of the Constitution, which follows one of the newest national system strengths by allocating a higher value to human rights treaties than treaties in general. The Article's first current text is a product of a constitutional reform that took place in 2011. As you can see, different historical perspectives to international law coexist in Mexico's current constitutional text. Mexico has always self-described itself as a law-abiding nation. Suppose we deepen into this policy origin. In that case, we can find that historically Mexico has upheld international law as a preventive self-defense mechanism against some of the United States' historical interventionist policies. It is essential to recognize the bilateral relationship asymmetry that has always set the rhythm between Mexico and the United States interaction. For these reasons, Mexico's conservative approach to international law has allowed it to have the freedom to differ from the United States in some topics that might be important to their foreign policy and avoid further interventions into its territory and internal affairs. Like any other country in the world, there are some instances where some local authorities go rogue, or because of ignorance of international law, it is not applied at first by local courts in Mexico. Still, in the end, they require measures taken on the federal level or by Mexico's Supreme Court to secure compliance with international law in Mexico. I hope this video helped you to understand better how international law is incorporated and recognized in Mexico. Thank you very much for your attention. Don't forget to like the video and to subscribe to the channel. Until next time.